Jogee and Ruddock and the Queen.
Yeah, Mr. Knowles.
Thank you, my Lord. My Lords, can I just give you one reference, please, for your note, without turning it up, but it was something I would have come to yesterday had I a little more time, but can I just ask you to note it? It's the dissenting speech of Mr. Justice Kirby in Clayton in the High Court of Australia. Clayton, as you know, was a decision where the High Court of Australia was asked to look at what we are calling PAL. The majority declined to do so and upheld it for the reasons they gave, but in what can, I think, properly be described as a powerful dissent, Mr. Justice Kirby set out some or all of the objections to the doctrine as he saw it. And can I just ask your Lordships just to note that? I'm sure you already have. Before I turn in my final...
Well, could you give us page references?
Oh, I beg your pardon. Sorry, it's B37. Is the start of his dissent.
Thank you.
I can give you the start of the judgment is at, it's tab 3, yes, the start of the judgment is B23, and his dissent starts at B37.
Thank you very much.
Thank you. So before, in my last half an hour or so, in which I'll deal with the grounds of appeal, can I just deal with the outstanding matter from yesterday, which is jury directions, which my Lord Hughes asked me to think about overnight. We will, I hope, in the course of the day, perfect a written document, but can I just sketch out now two directions based on the two approaches that I dealt with yesterday. The first is a common enterprise based on intention. We would ask the jury to go through the following route to a verdict. First of all, we'd ask the judge would direct the jury whether they were sure that S intentionally assisted or encouraged another participant P in, for example, an ABH. If no, then S would be not guilty, and the jury would be directed to proceed no further. If yes, they would be asked to go on to question 2. Question 2, are you sure that in being a party to that common enterprise, ABH, S intended or believed that someone would be killed or caused grievous bodily harm as part of that common enterprise? This includes the situation where S intended or believed that someone would be killed or caused grievous bodily harm only if a particular condition was met. As to intention, if you're sure that S foresaw death or GBH as virtually certain in the course of the enterprise, then it would be open to you to find that he intended one or other of those outcomes. If you are sure, your verdict is guilty of murder. If you're not sure, go on to consider question 3. Question 3. Are you sure that having regard to the manner in which Are you sure that having regard to the manner in which S intended or believed that crime, for example ABH, was to be committed, are you sure he intended or believed that it would result in some injury to a person falling short of grievous bodily harm? If so, your verdict should be that S is guilty of manslaughter. If you are not sure, your verdict should be one of not guilty.
You can let us have a copy of that.
Yeah, yes, we will. It's virtually finished, but I'd like to finesse it.
Of course, no, I understand.
The last one makes the test for manslaughter the defendant's state of mind in relation to harm rather than the objective judgment of the risk that the unlawful act carries.
Yes.
You might want to think about that.
Yes. That's one of the matters that we're under consideration.
Reid that we looked at takes a firmly objective approach.
It does, yes.
Yeah.
It may be that that's not the definitive version that your Lordships get, but that's where we've got to.
Okay.
The second, and this is entirely separate, this is an endorsement that I was...
This is your authorisation alternative?
Yes, that's right. But as my Lord Thomas and Lady Hale pointed out yesterday, this isn't my primary target.
No.
But I was discussing with Lord Hughes at the end of yesterday endorsement, and the direction that that I take responsibility for in relation to that is this. First of all, the jury would be directed about participation in similar terms. Then they would be given a direction about foresight in the terms which we have been dealing, and then this is the third element. Are you sure that in being a party to that common enterprise to commit the crime A with foresight, the defendant S, on all the evidence, including his words and behaviour and all of the surrounding circumstances, endorsed these actions in the sense of wishing them to happen, authorising them, or approving of them? If you are sure that there was endorsement in that sense, then your verdict should be one of guilty. If you're not sure, then your verdict should be one of not guilty. So I think the nub of the point that Lord Hughes was asking me with respect was, what do I mean by endorsement? And I offer those elucidations of it, wishing to happen, authorising or approving of them. In other words, something that carries the tone of approval, if you like, rather than just foresight simpliciter.
Thank you very much.
So, my Lords, coming then, please if I may, to the grounds of appeal, so far as Mr. Ruddock is concerned and the actual facts of the case. Your Lordships gave us leave in respect of 2 of our 4 grounds in the petition. The first ground of appeal is that the judge failed to give a correct or accurate direction on joint enterprise. And this is even on orthodox.
Quite, no, I understand that, yes. When I assuming you've lost on the
absolutely.
On the point that we've been majoring on,
Yes, absolutely. And the second ground of appeal is that the judge wrongly permitted prejudicial hearsay to be adduced.
Which is a completely separate point.
Which is a completely separate point. My Lords, I won't rehearse the facts. You will have read...
you deal with it very fully in your written case,
yes, no,
which we're very grateful.
I'm going to pick it up. I'm going to follow the written case. I'm going to pick it up, if I may, at paragraph 17.
Thank you.
Which is 371 in the Ruddock record.
Right.
In the course of his summing up, the judge... this trial followed the familiar pattern of many Caribbean murder trials, in that one has defendants or suspects identified pretty quickly. No doubt in small communities word gets around as to who's maybe in the frame. Defendants arrested, confessions or admissions made to the police, which are then at trial resiled from, an unsworn statement from the doc in some shape or form, and then usually a very short jury retirement. I think it was 17 minutes or thereabouts in this case before a verdict is returned. And that was the pattern in this case. The entire evidence against Mr. Ruddock, the co-defendant having pleaded guilty, as your Lordships will have seen, the entire evidence against Mr. Ruddock was admissions he was said to have made in police custody. The judge summarised what the prosecution case was in his summing up, and we've set it out in paragraph 17.
Yep.
The evidence that the prosecution relied on was that Mr. Ruddock was found with Mr. Hudson, and Mr. Hudson pleaded guilty to the murder, although I don't think that was in evidence before the jury.
No, it wasn't.
No. Mr. Robinson, the unfortunate deceased man, was bound and had his throat cut, and the prosecution's case was that must have required more than one person to do that. The car was seen being driven sometime before it was stopped by the police, and Mr. Ruddock stated that he was stopped when he'd finished working. When Mr. Ruddock was informed that someone had been murdered and his car reported stolen, he didn't reply to the police. When Mr. Ruddock was informed that a woman claimed to have seen him do something to Mr. Robinson and implicitly kill him, he made no reply. And this, crucially, when he was arrested, Mr. Ruddock said to the police officer, in the presence of the police officer, said to Mr. Hudson, "Anna me tell you fi cut the man's throat." We interpret that as meaning, I didn't tell you to cut the man's throat.
I did not tell you to.
Yeah, I did not tell you to cut the man's throat.
Thank you.
It's right to say that was what the officer said in chief. In cross-examination, as your Lordships will have picked up, it emerged that something different had been written in the statement. What was said to have been written in the statement by the officer was, quote, "You think me tell you fi cut the man's throat." And that's page 138 of the summing up.
Thank you.
Yes, is the sense different or not?
Well, the prosecution argued there was no difference.
Yes.
That on either formulation, Mr. Ruddock was blaming Mr. Hudson for the murder, but saying, I didn't tell you to do it, or I wasn't a part of it. Now, as I'll come to when I elaborate on my submission, Those two statements plainly raise the issue, or capable of parasitic accessory liability, because it may well have been in the jury's mind, well, Mr. Ruddock admitted being part of the tying up and the robbery, but he was saying, I didn't tell you to do the stabbing.
Right.
So it was a case, we submit, that called for a parasitic accessorial liability direction, and a correct one, because the jury would have had to have been directed in what circumstances is Mr. Ruddock going to be guilty of a murder if he told Mr. Hudson, even though he told Mr. Hudson not to do it.
I see.
Did he at any point suggest that he'd told him not to, as distinct from that he hadn't told him to do it?
No. Well, if the jury interpreted this as, I told you not to do it, or I didn't tell you.
I didn't tell you to, I think.
I didn't tell you to do anything.
Yeah. But, yeah, all right.
However the nuance is put on it, we say PAL plainly arose on the fact of this case because it was a classic robbery and with a murder coupled with it. Now, the judge's direction on joint enterprise we find at page 128. And it starts at line 15. So it's after a break. Mr. Foreman, members of the jury, just before we took the break for lunch, I told you that I would move on to what is the most important aspect of the case as it relates to the indictment and direction that I will give you. And that is in relation to something which was mentioned by the prosecutor, that they are relying on joint enterprise or common design. The prosecution's case is that the defendant committed the offence jointly with Mr. O'Neill Hudson. Now, where a criminal offence is committed by two or more persons, by more than two persons, each of them make their different part. But if they are acting together as part of a joint plan or agreement to commit it, they're each guilty. The word plan or agreement do not mean that there must have been something formally, and the agreement to commit the offence may arise on the spur of the moment. It can be by a look or a nod to each other, or it can be inferred from the behaviour of the participants. In this particular case, the prosecution is asking you to say that there was a joint enterprise based on what the prosecution has put forward as evidence of the behaviour of the participants. The essence of joint responsibility for a criminal offence is that each defendant shared a common intention to commit the offence and played his part in it, however great or small, so as to achieve that aim. So what he's saying here, Mr. Foreman and members of the jury, if two persons set out to do a particular thing and each play a part, even though one might be a minor player, as long as this is a part in relation to this joint enterprise, then each person will be responsible for the outcome of that joint enterprise. Now, your approach, therefore, members of the jury, should be this. If looking at the case, you are sure that the defendant did an act or act as part of a joint plan or agreement to commit it, he is guilty. Put simply, the question for you is this: were they in it together? As I've said, Mr. Foreman, members of the jury, the prosecution must prove that each defendant shared a common intention to commit the offence. Now, you might ask, what is the common intention? Common intention means either that the defendant each intended, or the defendant whose case you are considering. Pausing there, that must have been confusing. There was only one defendant, but...
Well, it's come off the word processor, hasn't it? Yes.
But anyway, the defendant each intended, or the defendant, well, it's the whose case you are considering. There was only one defendant for them to consider. But anyway, knew that there was a real possibility that the other defendant might have a particular intention, and with that knowledge, nevertheless, went on to take part in it. The law is that by participating in this act, with the knowledge that he has taken, with this knowledge, he is taken to have accepted the risk that his co-defendant acted beyond what was agreed, and adopt those acts is responsible for them, even if he would have preferred they did not occur at all. So once you were find they were acting together, Mr. Foreman, members of the jury, to commit this offence, then each would be guilty if the offence is committed. So in this case, Mr. Foreman and members of the jury, what the prosecution is asking you to say is that they intended to rob this man of the car, and in doing so, they tied him up and cut his throat. Now, you'll have to look at all of that to see what you make of it, from what you accept, that this is how he was found, bound hands and feet and throat cut. You'll have to look at it. Was this the work of one person, or is it the work of two or more than two? So if you apply your common sense to all of this, Mr. Foreman and members of the jury, to see what you make of it. And then he goes on to consider the evidence. So that was the direction. Now, there are parts of that which are relatively clear, common purpose directions. One typically sees the phrase, were they in it together? But we say what he failed to do was adequately or clearly explain to the jury that Mr. Ruddock was only guilty if he foresaw a real risk that Mr. Hudson would kill with intent to do so or to cause grievous bodily harm.
There wasn't a separate count of robbery, was there, on the indictment? This was purely a one count.
No, it was one
indictment.
count of murder.
So you haven't got the standard directions that you've got to consider the two cases, two charges separately. No. So when the judge speaks at 1:30 about the must shared to commit the offence, there were actually two offences which were relevant to the offence. The offence, what she, I assume, must mean there is the offence with which he's charged.
Well, that's one of the problems in this passage.
It's totally unclear.
It's totally unclear as to
Which offence is being talked about.
And he also introduces the word act as well. If you look at the bottom of page, I have some focus submissions, but just while we're on it, if you look at page 130, 5 lines from the bottom, the law is that by participating in this act, well, this act there must be the robbery, because he then goes on to say, participating in this act with the knowledge that he has taken, with this knowledge, he's taken to accepted the risk that his co-defendant acted beyond what was agreed. So there he's talking, he gets close to the language of PAL without actually explaining what the right principles are. But
well,
to echo...
is the nearest that he gets to it, and maybe close enough, I don't know, at 1819.
Well, yes, indeed, yes.
In the case of this defendant, did he know there was a real possibility that the other defendant might have a particular intention, and that, in this case, is to kill him?
Yeah, although he didn't say that.
Yeah, I grant you that.
And I anticipated a point like this being made, is that close enough? Well, I would respectfully say not, for a number of reasons. This is a difficult area of the law, that is well recognised. I think we can all agree on that at least. These were oral directions to the jury rather than a route to verdict. The judge had some time earlier in his summing up, obviously directed the jury as to what murder is. But given the importance of the topic, as the judge himself says in his introduction, this is the central issue in the case. Given its importance, this was a case, we submit, that called for nothing less than a full and accurate direction on parasitic accessorial liability on orthodox principles, including 2 points, neither of which we say emerge from this passage. First, as I've said, there is no direction that they had to be sure that Mr. Ruddock foresaw that Mr. Hudson would kill with intent to do so or cause grievous bodily harm. And that's an essential component. He says a particular intention, but the jury could well have not understood what he was talking about.
Well, that's what's troubling me. I mean, everything you say is, from a lawyer's point of view, absolutely right and very interesting, and that the academic lawyer who's examining directions of this kind would ask all those questions. But this was a case about somebody whose throat had been cut. What else could it be about?
Yes, as a matter of fact, that's right, but the jury have to assess the facts against the right legal framework, and if they're not told what the framework is...
I see. Yep. Okay.
And the second point about this direction, which it fails to cater for, there is no direction about fundamentally different acts. Fundamentally different acts.
I'm sorry, yes.
And we say that was an important direction to give in the context of this case, because there was simply no evidence as to whether Mr. Ruddock knew that Mr. Hudson had a knife at all. It's described as a ratchet knife. I'm afraid I don't know what a ratchet knife is, how big or small it is, whether it folds up in a pocket or whether it's a large machete. But in the absence of the point I'm making, Lady Haley, is i.e. a knife that Mr. Ruddock couldn't have failed to notice in the course of the robbery. But it was a case that called for a fundamentally different acts direction, because the jury, as one component, would have had to have been sure that Mr. Ruddock knew that his co-defendant had a knife. And they had to be sure that, even if he knew he had a knife, that he foresaw it being used in the way that it was used, as opposed to just threaten Mr. Robinson, the deceased person, or cause a lesser degree than harm was cut. than was in fact inflicted in the cut throat. So just to summarise, therefore, in I hope a focused way as to what we say the errors were, there was a blurring of an intention and foresight. Common intention means either the defendant each intended or there was a real possibility. Well, again, I may be being overly lawyerly, but foresight is a possibility isn't an intention. So it's a misdirection to tell the jury foresight is intention, because it's not.
Can I just ask you this? I'm just trying to see how the judge identified the issue to the jury. Page 131 in the passage following that you were asking us to look at, the judge there identifies what the prosecution say was the joint enterprise, line 7. Prosecution asking you is that they intended to rob this man of his car, and in doing so they tied him up and cut his throat. Now, it may be rather a semantic point. She's not saying it was the joint purpose was to do both, but the joint purpose was to rob, and this happened in the course of it. Then right at the end, summing up, towards the end, page 160. 160, line 13. You can only find him guilty if you accept the evidence led by the prosecution, if you accept that he was part of this common design, this joint enterprise to rob and kill Mr. Robinson. So she's treating it as one matter. Now, did she anywhere in the summing up say, now, there is a difference between robbery and murder, and you've got to satisfy yourself, firstly, that he was party to the robbery, but that's not what he's charged with. And secondly, and this is what he's charged with, that he was party to the murder, and give directions about what they would need to consider in relation to that. No, there's nothing anywhere in the summing up saying effectively that it's one thing, because his on one interpretation, what he'd said to the police could have been a virtual admission of being part of the robbery, but a denial of being part of the killing.
Absolutely, which is why I preface my submissions with what he said. Although the prosecution's case was, this was a robbery murder from start to finish, they both murdered, they always intended to murder, that's what they went out to do. Mr. Ruddock's statements to the police did raise as a real possibility that that wasn't right, that it might have been a robbery, but it was something that turned into a murder because of what Mr. Hudson did, unauthorised and unforeseen by Mr. Ruddock.
It all boils down to the point that you've got to focus their mind, you say, on the possibility that it might have been one but not both.
Yes, absolutely.
Is that it?
Yes, absolutely.
Okay, so that's the first additional point, as it were. Is it?
Yes.
And then we have the hearsay. Or was there anything else you wanted to say on this point?
No.
We have your written submissions, as I indicated.
What we essentially say about this direction is it's part common purpose.
Yes.
It's part PAL, although it doesn't quite get there because he doesn't specify what he has to foresee in actual accurate terms. There's no direction about fundamentally different acts. And all of those were real live issues on the evidence that needed to be catered for in a proper direction. Coming then, please, my lords, to my second ground of appeal, which you find at paragraph 31 onwards in our written case. Your lordships know that it was Mr. Spence who found something on Mr. Hudson's phone. One can speculate, I think it was a picture, and one might be...
Picture of a woman.
Yeah, one might be able to speculate what it was about, although there was no evidence actually about it. The woman was identified, as your lordships know, but did not give evidence. Miss D.C. Spence returned to Mr. Ruddock after interviewing her and stated that the female had explained to me that told me all what they have done to her and the deceased, Pete Robinson, while they were on the beach at White House in St. James. And that was evidence, we can look at the transcript, but that was evidence that the officer was permitted to give. This evidence was led by the prosecutor, as we know, moments after a warning from the judge that she should be careful in asking the question because we don't want hearsay to come in. And we say that this was highly prejudicial evidence, and self-evidently so. There was the loaded comment, they told me all what they have done to her. All right, it wasn't ever said what that was, but as a matter of fact, there was a charge of rape at one stage, although that was not pursued. But it's a short stretch that the jury must have understood what they had done to her to have something sexual, or something criminal, and we say something sexual to her. But also, this was a hearsay statement by an absent witness who claimed to have witnessed the murder of Mr. Robinson that was the very issue before the jury, what they have done to her and to the deceased, i.e. they both to the deceased. And Mr. Ruddock gave no reply to this, so it's not even as if it was somehow admissible in the context of some admission that he was then prompted to make.
But does it all depend on the... I'm looking at the transcript, it's 68, but you've set it out in your...
Yes.
Your 31 is just as good. Is it in effect the words to her which are the objectionable part? Because what if anything, would the hearsay statement have added to Mr. Ruddock's confession that he tied the chap up?
Well, it's...
in relation to the deceased?
Yes, well, it's what they have done to her and the deceased.
Her, I understand.
Yes, but, yeah. Well, there's prejudice because there's a suggestion that there's something criminal to her as well.
Yes.
But so far as the deceased is concerned, they and the deceased, it's an allegation that they both committed the murder, or can be interpreted as that.
Well, it isn't, is it?
Well, the words "what they have done to the deceased"
I see.
could have been interpreted by the jury that this woman had told the police, "I witnessed them both killing the deceased."
Right.
And Mr. Ruddock's defence, of course, was no, that was nothing to do with me. I was part of the robbery, but that was something beyond the common purpose.
Yeah, okay.
At a minimum, my lords, the jury should have been directed that this had no evidential status. And in fact, we go further. They should have been directed to ignore it. There was no application to discharge the jury, I have to accept that. But as a minimum safeguard in the summing up, the judge ought to have directed the jury to discard it. We've set out what the judge actually said in our paragraph 35.
Yes. Yes.
See, he did say that they'd not heard the witness, couldn't speculate on what she said, but he then went on to say the following. Having spoken to this lady, Corporal Spence went back to Ruddock, said he located the lady, told him what they did to her at White House on the beach and what they did to Mr. Robinson. So you'll have to look at that, Mr. Foreman, members of the jury. This is what was said of Ruddock, and what was his reply? There seems to have been no reply. So in fact, having told the jury not to speculate, he then places evidential significance on it. And so the additional point I would make in response to my Lord Hughes is what did it add? Well, the judge plainly thought it added something because he highlighted it to the jury as something they should think about.
Yeah.
And so we say, in summary, in paragraph 54, this direction compounded the prejudice caused by the admission of the evidence. And my Lord, and that's it, so far as that ground of appeal is concerned.
Thank you very much.
Just two footnotes, please. I mentioned this at the outset. I just mentioned it again for completeness. We have the appeal on sentence, which is unopposed. And can I just correct, please, because I don't want to take a bad point. Could I ask you to strike out paragraph 27?
Very well.
That was based on a misreading. I took a point.
Well, fine, if you want to strike it out, that's perfectly
Yeah,
fair.
just to explain, it was based on a misreading of the summing up. That's
Perfectly
not the point.
understandable.
So, my lords, I hope, well, bang on time. Is there anything else I can assist with at this stage?
Thank you very much indeed.
Thank you.
Thank you, Mr. Nelms. Mr. Meagan. Thank you. Good. Mr. McGuinness.
Please, the court. Lord, my lady, in the light of the fact that the various contentions are set out fully in the printed cases, I'm going to confine my submissions to three matters. Mm-hmm. Firstly, the basis and the justification for the foresight test as a preferable way of expressing criminal liability to that of common purpose or common design. Second, I'm going to address, my lords and my lady, on where manslaughter fits in, and the question as whether manslaughter does still fit in, and in the respondent submission it does. And thirdly, I will deal briefly with the facts on the Jogee appeal, because one of the points that was mentioned in the printed cases, and it was referred to in the Court of Appeal, was the Court of Appeal had a transcript of the judge's half-time ruling, because they quote from it. Until this morning, none of us had ever seen the ruling, but it's now materialised. And I imagine, I don't have the copies, but I think somebody else does. They're all... Yes. They weren't in the bundle, and they've now been found. And therefore, I will refer briefly in the third part of my submissions to the reasons that Mrs. Justice Dobbs gave for refusing the submission of no case.
Thank you.
Lord, as far as the foresight test versus the common purpose or common design test is concerned, it would appear from a review of the authorities that the modern foresight test has developed out of the common purpose test. And no bad thing, says the respondent. We are all here today, both these appeals are concerned with judges' directions to juries. The foresight test we submit is a test that is designed to be understood by juries who have to return just verdicts in what are often difficult cases. Lord, I quote from Lord Hutton in Powell and English, which we now have at tab 137.
Yes.
It's electronic page B3506 at 3536.
Thank you.
What Lord Hutton said towards the end of his speech in Powell and English was this: I consider that the test of foresight is a simpler and more practicable test for a jury than the test of whether the act causing the death goes beyond what had been tacitly agreed as part of the joint enterprise. And we would endorse those observations. I'll come back
That doesn't make it right, though.
It doesn't, no. It doesn't
Well, it
make
may
it right.
make it convenient,
but it's
it
an
doesn't make it
argument
right.
that it's right. And I accept, of course, my lady, that that is not the be-all and end-all of it. But when one bears in mind, as I've indicated, that the purpose of the law in this area is to ensure that juries are given directions that they understand, the respondent does submit that certainly in the late 20th and 21st century, juries will more readily follow directions that deal with issues of foresight than with such concepts as common purpose, common design, what has tacitly been agreed, what has been authorised, what has not been authorised. When one looks at much of the historical material that is before the court, we can see that the language that was used in the commentaries in earlier centuries and in many of the cases that are before the court, certainly up to or prior to the 1950s or thereabout, the language used is not the sort of language that we tend to use today. And many of the commentaries and many of the cases in this area concerned instances of command and solicitation cases, often dealing with what is an accessory before the fact, where by definition, if you're looking at an accessory before the fact, there has been some form of communication from the accessory to the principal, because, as you know, in those days, the murder felony rule caught those who were present at the scene and participating. So one has to bear in mind when one looks at the language that was used the examples that were often being given. Also, too, when one looks at some of the old cases, there are cases that revolve around what were clearly pre-planned or pre-organised criminal ventures. The poaching cases are a good example. People would go out during the day or during the night for the specific purpose of poaching. That would be crime A in the scenario that we're dealing with here. And therefore, the issue of crime B, what would happen if the gamekeeper was encountered during the poaching expedition, and what was to be done if they were unlucky enough to come across the gamekeeper, would be a matter that, if this is where we have a pre-planned, pre-organised crime A, was a matter that was likely to have been, if not discussed, at least positively or actively contemplated by those involved in crime A. And therefore, in those types of cases, it may well have been sensible to look at crime B, the offence that was committed once the poachers were apprehended or attempted to be apprehended by the gamekeeper. It was sensible to look at crime B through the prism of the language of common purpose. How did the undoubted and necessary common purpose of the parties to commit crime A, which is still a requirement, transmit through to crime B, so that it could be said, there being a common purpose to commit crime A, that the common purpose to commit crime A also became a common purpose to commit crime B. But there is only one principle, and the principle must also apply to spontaneous cases of joint venture, where there has in reality been no such pre-planning, pre-organisation or discussion. And not only must it apply to spontaneous cases of joint venture, it must apply too to cases of spontaneous violence, often involving participants who've only come together very soon before the activity, and very often, though not always, involving people who are under the influence of drink or drugs. And in those circumstances, it may be with a jury a little unreal to direct them along the lines of common purpose or common design or tacit agreement. And
I mean, but sorry to interrupt you, but there is, you accept, I think, that the law was like that down to wherever we pitch it, whether it's 1950 or 1985, it was plainly premised on common purpose.
Certainly the language that was used up until about that time, as shown in the historical material, tended towards expressing it by way of common purpose or common design. There were some exceptions. My lord's been referred, the court's been referred, for example, to the case of Pridmore by Mr. Knowles. But yes, generally yes, and it may be a coincidence or not, but of course the 1957 Homicide Act abolished felony murder, which meant that the fact that judges didn't have to work very hard about what to direct a jury, about participants who were not the principal present at the scene of the crime, as to their mental element, as to their mental state, became rather more acute once one couldn't simply say to the jury, well, if they're all in it together and one of them committed the murder, then they're all liable.
The reason I just really wanted to know, are you saying that actually all that's changed is linguistics? Or are you saying that there's been a more fundamental change to meet modern circumstances?
It's a bit of both, my lord.
That's what I thought. Sorry to interrupt,
but
I wasn't quite sure which way you were going, but it's a bit of both.
It is a bit of both. Certainly the language has changed, and the language has also changed because, as I think is clear from the problematic case that Lord Mustill discussed in his judgment in Powell and English, perhaps more acute when one talks of spontaneous offences and spontaneous offences of violence, that you can have a situation in which somebody does have the necessary foresight, but is still a reluctant or unwilling participant, but is a participant nonetheless. I'll come to Lord Mussel's judgment, but Lord Mussel had a difficulty with squeezing that type of case into into common purpose. It's interesting when we look at it, his solution was to go to Chang Wing Si to meet that sort of problematic case. What the rest of the House of Lords decided in English and Powell was that you didn't need, as Lord Mussel would have preferred, to have retained common purpose for all of those cases where it neatly fitted the evidence before a jury, but then revert to the Chang Wing Si foresight test for the problematic or difficult cases where it didn't so fit.
Before you move on, could I just ask you, no doubt everybody else merely needs to be reminded, but I need to be told, what were the reasons for abolishing the felony murder rule?
Because it was held that for those simply present at the crime, assisting another crime, by virtue of that, to be guilty of the crime of murder was unjust.
Well, it's not only the accessories for whom it was abolished, it was abolished for the principal as well.
It was abolished for the principal, yes.
And the way constructive malice, as it used to be called in England, or felony murder, as it's called elsewhere, worked, as I understand it, correct me if I'm wrong,
It was before your time.
even before my time. If you were engaged in a felony and death resulted, that was murder.
Yeah. Yes.
Hence, for example, Mr. Beard.
Yes. Correct.
But it wasn't a rule for accessories. I mean, it applied to accessories, but it was a rule for everybody.
Yes, it was a rule for everybody. And accessory liability, in one sense, has been entirely unaffected.
And is the answer to my lady's question perhaps that the view was taken in 1957 that guilt of murder, thinking for the moment of the principle, needed to be tied to a relevant intent?
Yes.
I think that was the subtext behind my question.
Can I just ask you this, Mr. McGuinness? You're saying that foresight is preferable to intent or common purpose because it's easier for a jury and it's a bit impractical to be looking at joint intent where you haven't got a true conspiracy, but simply a group of semi-drunken people who've assembled. That's the thrust of your present submission, I think.
Foresight, my lord, is only one aspect of the test. It's not simply foresight. It's foresight coupled with, once you have that foresight, lending yourself to the commission of crime B, and crime B being committed.
Well, of course, lending yourself to commission is itself tendentious because it's a question of what are you lending yourself to.
Yeah, well,
you're doing acts. We all agreed there has to be the actor's risk. You have to do something which is capable of assisting or encouraging. But you're saying that in looking at the mental element, in whether those acts capable of insisting or encouraging by, for example, being part of a case, should carry secondary liability for the full offence, the shift in test from common purpose, which is an intent-based test, to foresight, you said, is not merely linguistic, it has a substantive element, and you're putting forward the reasons why that is preferable.
Yes.
You've referred us to Lord Hutton, and you're developing that theme by saying that it's pretty theoretical, to say the least, for the jury to have to work out what was a shared intent in the type of assembly of people we're talking about. I think I've correctly understood the thrust of your argument.
yes, my lord.
And can I just think about that for a moment? And I'm sorry to quote myself, but can I just look at something I said in Mendes, which is really addressing this point, of the alcohol-fueled loose group of people. It's 696, paragraph 48.
Well, I think for the rest of us, we're now working from the new
Right, where's that?
additional authorities, and it's tab 135, electronic page 3465.
Now, it's just a short sentence I wanted to...
Which paragraph?
48.
Thank you. So that's page 43479, yep.
It's 3479, yes, my lord.
And
That's not how it works. That's not how it works.
Yep.
start.
Oh, well, it's just that the documents go to sleep and have to be closed and reopened if they're left overnight, and they have been left overnight. So I'm having to reopen them all. No, it's okay. I must get it sorted. Carry on. I can listen and do this at the same time.
Yes, which,
Quoting, in a case of spontaneous or semi-spontaneous group violence, typically fueled by alcohol, it's highly unlikely that the participants will have thought carefully about the exact level of violence and associated injury which they intend to cause or foresee and may be caused. Your point.
Yeah.
All the jury can in most cases be expected to do is to form a broad brush judgment about the sort of level of violence and associated risk of injury which they can safely conclude the defendant must have intended or foreseen. Now, what's more difficult about doing that exercise in relation to what he's intended than what he's foreseen?
Well, although intended is used there, intended isn't required, is it?
Well, if you're looking at common purpose, intent is
My lord, I don't think there is looking at. My lord, I think there is referring to the foresight test.
Yeah,
But
my question is, given that sort of exercise the jury's got to do, why is it more difficult for them to say, right, well, what must he have intended, than to say, well, what must he have foreseen?
Well, because with foreseen is a predictor, isn't it? Intention is a state of mind. They're not.
Well, foreseen will sweep a wider net, but why is it a harder exercise?
you say foreseeability is objective and intended is subjective. Is that your point?
Well, no, it has to be subjective.
Quite,
It has to be what the defendant.
Exactly, exactly. So why is it easier? Once you accept they're both subjective, why is it easier? It's exactly my point.
Well, because if one's talking about intention, one's talking about then one's moving back towards basic accessorial liability, is one not?
Yeah, but why is it easier? Why this is really picking up the Lord Hutton point. Why is it easier to look at foreseeability, subjective foreseeability rather than subjective intention? I can see if it's objective, there is a difference, but as you say, it's subjective.
It's not so much because it's easier, my lord, it's because the jury, on the evidence, are more able to take an approach to the issue of foreseeability than perhaps they very often are with intention.
Well, more people will be convicted. I think that's your point.
Well,
But you started off by taking
it is wider. Obviously, my lady's arithmetical point must be right.
It must be, mustn't it? Yes,
if
of
intention and foresight will
Yeah.
either will be required, you'll get more convictions if you have both than if you only have one.
But the point is, you started off with Lord Hutton saying it was simpler, more practical.
Yes.
And what we're testing is why.
Well, I quibble, with great respect, I quibble the use of the word intended here. That would not, in what we call a parasitic accessory liability direction, be one that the jury would need to deal with, because we accept it's not a question of intent.
But I agree with that. If we wind back to where it was before we went down the Jiang Wang Tzu route, where we were back in the world of intent, common purpose. The question which we're all probing is, why is it inherently more difficult for a jury to say, looking at the reality of the situation, he must have intended this, rather than he must have foreseen this?
Because we're talking here about a second crime that's flowing on from the first crime, and by definition, the defendant whose case is being considered the secondary party here is not intending to commit the second crime, crime B. But the law is saying that the mere fact that you don't intend to commit the second crime, crime B, is not the end of it. This isn't somebody who is behaving lawfully and the Crown would have to prove that he has intended to commit the offence. These cases deal with persons who are already engaged in a criminal enterprise. The groundwork is being laid for the commission of crime B. The defendant is a participant in crime A, whether as a principal or whether as a secondary party. Looking backwards, because one is looking from the trial back to what happened, crime B has been committed, more often than not murder, and the jury is asking itself, in addition to the principal who will be convicted if he or she has committed the act with the requisite intent, are there any other persons who were with the principal who may not themselves have intended that crime B be committed, but foreseeing that crime B might be committed, have made the decision to go on and to help the principal to commit crime B?
Yeah, but that's simply to restating what the current test is, and what we're examining is whether that should be the test.
Well, the answer, my lords, from the respondent
Is yes.
is that yes, it should be.
But I know, but saying it is the
There are-
test
Well,
doesn't mean that it
Could I ask you to think
remain
about
the test.
Could I ask you to think about the possibility of contingent or conditional intent? The 19th century paradigm of a crime A, crime B situation is probably conveniently poaching, and the clearly possible arrival of the gamekeeper. There must be plenty of modern equivalents, but one is a wages snatch, where if there is resistance, the question is what's going to happen. Now, can the state of mind of the follower, the driver, the assistant, the accessory in the wages snatch, who isn't the one who's carrying the sawn-off shotgun or the baseball bat, be analysed in terms of a conditional or contingent intent that it should be used if necessary? Or doesn't that work?
Well, it doesn't work in many cases of spontaneous violence.
Well, leave spontaneous violence on one side for the moment. I know about spontaneous violence. I'm about to come to that. But you started us on crime A, crime B.
Yes.
Let's stick with that for the moment. Now, can you do it in terms? Is it a proper analysis of the state of mind of the accessory in the wages snatch, that he has or hasn't, as the case may be, a contingent intent that the weapon shall be used if necessary? In other words, if they're not going to get away with the money otherwise.
It can be certain, my lord, yes, it can be properly expressed in that way, yes.
Right. So that foresight alone, I understand your proposition that foresight will more often be established, and that quite often the accessory may not have thought it through enough for the jury to be able to answer the question about intent. But if once you understand the principle that an intent may well be contingent or conditional, my question is, does that mean that the people who ought to be caught will be caught?
Yes.
Right. Now then, spontaneous violence isn't a crime A, crime B situation at all normally, is it? It might be.
Well, it has to be, the model has to be that, but it very often...
I've always wondered whether it does, but...
Well, because of the way these things are approached, it does have to, it does not have to be overt. The judge need not go into directing the jury about crime A or crime B. Jogee is a good example where the directions that the judge gave to the jury didn't go into the question of crime A or crime B, but it's apparent for Jogee to be liable that Jogee and Hersey had to be engaged on a criminal enterprise, out of which Jogee's conviction for murder might well be open.
Yeah. But the very distressing cases which we all had frequently of group attacks, where the real peril to the victim is in the numbers.
Yes.
And it's no good pretending that numbers don't provide encouragement. Of course they do. But in the case of the spontaneous violence, can you analyse it in terms of, can you analyse the state of mind of the herd in terms of who are in fact clearly supporting whoever it is eventually does the deed? Can you analyse that in terms of intent?
It's much more difficult there.
Why is it more difficult?
Because the events happen so quickly. All that is going through minds at that stage is helping, wanting to participate in the assault that is then taking place, whether by physical participation or by means of encouragement.
Yeah.
And the defendant contemplates, because of the circumstances of which he is aware, including, where appropriate, numbers, reputations, weapons, that something beyond a mere beating may well be on the cards.
Well, why don't you ask the question, did he mean, if necessary, did he mean that, if necessary, this victim should suffer grievous bodily harm at least?
Well, if you participate intending that the victim should suffer grievous bodily harm, then you're guilty as a basic accessory.
Exactly.
Yes, you are. We are dealing with cases. There's often a huge overlap, because one of the things that my lords will notice, and this is an example, is that very often in these cases, judges give both directions. They give a direction to the jury.
Yes, well, the question is why you need the second.
Which is why you need the second.
No, the question is why you need the second.
If
If you say to a jury in a multi-handed pursuit case, chased across the park and eventually that someone's left dead, if you say to the jury, question one member of the jury of this particular defendant, did he participate? And second, what did he intend should happen if necessary? If it's death or at least grievous bodily harm, it's murder. If it's something less, it's manslaughter. Does that or does that not meet the case?
it will meet some cases, but the problematical cases are those where there is a large group surrounding the victim.
Yeah.
During the course of the assault, somebody produces a lethal weapon,
Yeah.
which then kills the victim.
Yeah.
And when everybody is arrested and interviewed, that they all say, I had no idea.
Not me.
Not me, not me.
And I had no idea.
And I had no idea who. And in those sorts, in a straightforward case where that sort of issue isn't raised on the evidence, then, my lord, I agree that if you can keep it simple for the jury and give them a direction on one legal principle only, that is preferable. All of these types of cases are fact-specific and are governed, generally speaking, by the evidence, because in the typical type of example, if a defendant says, well, yes, I was involved in an assault, but I had no intention that the man should be seriously injured, and I certainly had no knowledge that anybody was going to and did produce a knife and stab him to death, then the jury has to be directed on a sensible basis as to how they approach whether or not the prosecution has proved his guilt. And this principle is such an approach.
Going back to your point about crime A, crime B, has anything changed in the last 50 years to require a change in the law as it had been applied for over 300 years. I mean, if you're looking for an example of a case A, crime A, crime B, I mean, Foster's 3 soldiers in the orchard, he identifies it very clearly. And I'm just wondering what's emerged new on the stage which has required this change of approach.
Well,
From looking at really what were they jointly intending, what was the common intention to, did he foresee this as a possibility? What's come new in society to require the change?
I don't think it's come new, my lord, but the three soldiers in the orchard is a very simple and straightforward case.
Right. None the worse for that.
Well, none the worse for that.
But today it would be a completely different approach would be taken. The direction to the jury would be a very different one.
Well, the direction to the jury may or may not be that different. In the case of the 3 soldiers in the up the tree, or was it 2 up the tree and 1 keeping guard?
Yeah.
The approach, the direction to the jury may or may be different. It rather depends what the investigation reveals about what people are saying and what their defences are. All of these directions have to be honed specifically to the issues in the case. Judges are always being told, don't cut and paste from specimen directions. Although the principles have to be there, you should hone even your directions to the jury, your routes to verdict.
Are you saying in some cases the judge could say intend and in another case he could say foresee, and they'll both be valid?
Well, 2 judges may take a different view of what the issues in the case require him or her to direct the jury on, my lord. But to answer Lord Toulson's point, it is not always necessary, simply because there are 2 potential routes to criminal liability, that the jury has to be directed on both. Parasitic accessorial liability is only ever forms a direction to a jury where the particular facts of the case demand it.
And in relation to the spontaneous joint enterprises, use that horrid phrase, has something changed in the world to require new principles of law? I mean, weren't mobs a fairly habitual experience of life in the 16th, 17th and 18th centuries?
I'm sure, my lord, that they were, but...
One's got what you accept was a significant change in the principle being adopted, and I find it difficult to find a precedential basis for it. You may be taking us to John's, but I find it difficult to see that it grows out of the earlier authorities, and I'm looking to see if there's some underlying policy principle reason that really drives it.
There are,
other than simply getting more people in the net.
well, there are policy reasons that drive these, which are set out in both our printed case and in the printed case of Ruddock.
But the problem,
it would be wrong to ignore that.
If it comes to simply sweeping up more people who have some involvement, the worrying problem about that is the fair labelling and disposition point, because if they're guilty of manslaughter, in the case of people who pre-Wang would have been guilty of manslaughter, their liability is now upgraded, so they carry a life imprisonment and the ticket of a murder for life. And therefore one's looking to see whether there are underlying reasons of justice that drive the relabelling and the putting them into a different sentencing regime.
My Lord, I don't accept that manslaughter is no longer an option. The respondent contends that it is, and what my Lord said in Mendes is wrong.
Right. Good.
But in terms of judicial explanations for the change, is the only one Lord Hutton's, to which you took us to in the final penultimate paragraph of Powell and English, or are there any other explanations given judicially for what may be said to be the change of policy identified by Lord Toulson?
It's also touched upon in the speech of Lord Brown
Thank you.
in Rahman.
Thank you.
And I'll take my
That's in
lords
the next, that's in the
to
next
Rahman.
tab.
That's also in the
Yes,
new
tab,
bundle.
tab 138 of the new bundle, yep.
As copied in mine, it's both tab 139 has been inserted halfway through the
I don't have that
report.
interesting. I don't have that interesting.
Oh, you don't? Well, just
But we have Lord Brown who starts at B356.
yes, and I wanted to take my lord to paragraph, starting at paragraph 62, which is B3571.
Thank you.
That isn't the electronic number.
B3571?
No. It's a separate file,
Yes.
separately numbered from 1 to 317.
Ah.
So
I have the same problem
I
as
think
my
what's
lady.
happened is that the
it's not a problem.
hard copies that we've been provided
Yes, they have been sequentially
they
numbered, but that
continue
hasn't happened.
sequentially after the end of the
But the electronic file is not so numbered.
No. So what is the paragraph number that you
It's
want?
paragraph 62 at page 163 of the law report. And at paragraph 62, Lord Brown sets out the certified question in Rahman. The certified question then asks whether that intention is relevant, one, to whether the killing was within the scope of a common purpose to which the secondary party was an accessory. And at 63, he says, the first question is misconceived. If the principal, the killer, was at all times intent on killing the victim and the secondary party was not, then it is simply unrealistic to talk in terms of their sharing a common purpose, but that matters nothing. Once the wider principle was recognised or established, as it was in Chang Wing Su, namely that criminal liability is imposed on anyone assisting or encouraging the principal in his wrongdoing who realises that the principal may commit a more serious offence than the secondary party himself ever intended or wanted or agreed to, then the whole concept of common purpose became superfluous. There really is no longer any need for judges to direct juries by reference both to whether the relevant actions were within the scope of the common purpose of those concerned, and also by reference to whether the secondary party realised that the principal might commit the acts constituting the more serious offence. The second limb of such a direction effectively subsumes the first. If the relevant acts were within the scope of the principal's and accessories' common purpose, necessarily the secondary party would realise that the principal might thereby commit the more serious offence. And if the secondary party did not foresee even the possibility of the more serious offence, such could hardly have been within the scope of any shared purpose. And then at paragraph 64, Lord Brown cites the passage
Yes, I see.
from Lord Hutton in English and Powell that I cited or referred to at the beginning of my submissions. That's where we've ended up, as it were,
Yeah.
as a result of...
But unless I've missed something, Lord Brown does no more in terms of justification for the change in the rule rather than explanation for the change in the rule, does no more than in the end than quote Lord Hutton as to the fact it's easier for the simpler and more practicable.
I think it's a bit more than that, isn't it? It's formulated, isn't it, in the middle of 63. Liabilities imposed on anybody assisting or encouraging the principal in his wrongdoing if he realises that the more serious offence may follow, but carries on
Yes.
participating, as
Yes.
it were. That's the justification for it, if there is.
It is. It's not, as I've emphasised, it's not just foresight. That's but one element. It's foresight, and then you make a decision to carry on, that there is a link between the second crime and the first crime. So it's an entire package as opposed to simply foresight being...
It's assisting or encouraging in crime A, knowing that crime B, foreseeing crime
Yes.
B.
It's on the cards.
is on the cards. And I suppose the policy justification for it is that the defendant is already out on a criminal enterprise of a type or of a sort, and during the course of that enterprise he has foresight that something more serious may happen, and with that foresight he says, well, I'll go along with it anyway, I'll lend a hand to whatever that more serious thing is.
But to go back to the question I asked you earlier, it is, I think, pretty clear that actually the law did change.
As I said,
And this speech, this passage at 63 makes it abundantly clear.
Yes.
And the real question in this case, isn't it, did the law take the wrong turning? Point one. Maybe, and you will no doubt come on to say, well, maybe it didn't, but even if it did, it's too late to change it.
well, certainly,
And it would be bad to change it because you would be letting out of those who ought to be made liable, you'll be letting them off. I think isn't that what this ultimately, expressed in very simplistic terms, the issue?
as I indicated when my Lord asked me the previous question, not only has the terminology changed, but there has also been a more substantial change than that. It is a recognition that the principle has to meet culpability, criminal liability, in situations that are not simply covered or aptly covered.
By the old doctrine of,
By the old doctrine.
of common purpose or joint venture.
My Lord, yes, and as I say, that was the difficulty that Lord Mustell expressed in Powell and English. But I've said it once, but I rely upon it. Lord Mustell's solution was to make use of the Chan Wing Use foresight test to catch, putting it in inverted commas, the defendant who ought to be criminally liable, but it would not be so easy for him to be proven to be criminally liable by just an application of the common purpose test. And so it has a utility because it is, I suppose, more flexible than the common purpose test. And yes, there are policy considerations behind it, which have been stated by judges over the years.
Can you envisage circumstances where somebody caught by murder under the new test would not be caught by manslaughter under the previous law?
Yes, my Lord. I was going to deal with manslaughter as a slightly different topic, but as my Lord has raised now, perhaps I could.
Well, I say I've raised it. You said that they would escape criminal liability if you did. There would be people who deserve criminal liability, but would escape criminal liability if you didn't have the more flexible foresight test. And I moment can't think of anybody who would fit into the category of somebody who would be guilty of murder under the present law and would escape criminal liability if one reverted to the law as it was.
Well, the example given by Lord Mustell in Powell and English, what Lord Mustell's concern was.
Wouldn't that person fall squarely in the category of person that Lord Justice Lawton spoke about in Reed?
That rather depends on what the individual foresees. My Lord, on the thorny issue of manslaughter, can I take my Lord to Mendes and Thompson?
But in a moment, I can't, if we're in the murder world, I can't think of a credible example where reversion to the less flexible test would result in less than manslaughter. I may be wrong. If you're in the non-homicide world, you do, of course, now have the statutory inchoate offences to consider also. But you want to come to Mendes?
Well, I want to come to Mendes just to deal with the discrete issue of the availability or otherwise of manslaughter.
Is that a convenient moment for you to do that?
My Lord, yes, it is. I was going to do it later, but I can veer off at this stage to do it and then come back.
Okay.
I was going to start with...
Tab 135, isn't it?
It's tab 135 of the additional authorities.
Yep. Sorry.
And it starts at page 150
Thank you.
of the electronic bundle, which nowhere appears on the printed page. So my Lord and I are in difficulty.
Yep.
But we'll do our best.
My Lord, my Lady, paragraph 21, perhaps I'll just refer to paragraph numbers.
Yeah.
It will be easier for everybody to follow.
It'll just take us a little bit longer than the others possibly to get to. Yeah.
25, did you say?
Yes.
My Lord Tilson referred in paragraph 21 to the judgment of the Court of Appeal in the case of Reed Barry and cited from the judgment of Lord Justice Lawton. He then continued at paragraph 22. Reed no longer represents the common law in England and Wales on the question of the availability of manslaughter as a possible verdict in cases of that kind, because in Powell, the House of Lords adopted a different analysis of Anderson, which excluded the possibility of a manslaughter verdict in such cases. And then at paragraph 31, which is 2 pages on in the copy of the report, my Lord had been discussing various matters at paragraphs 25 through to 29, and you continued at 31. Other relevant factors have been the adoption of the principle in Chan Wing Siu and the removal of the ability of the jury to return a verdict of guilty of manslaughter in circumstances where D sets out with others on a criminal venture in joint possession of weapons, but without intent to kill or cause serious bodily harm, and P murders V in the course of it, the scenario considered in Reed. And then finally, over the page at paragraph 38, my Lord said, some would argue in company with Lord Mustill in Powell that where D and P embark on a criminal venture in which P goes further than D wishes, but foreseeably so, D has a measure of culpability for P's act and V's resulting death, but usually at a lower level than P. When Reed was good law, the difference was accommodated by the possibility of a manslaughter verdict, but that is no longer available. D is guilty of murder. My Lords, with respect, what is said at paragraph 31 in particular, that manslaughter is not available where the defendant sets out with others on a criminal venture in joint possession of weapons but without intent to kill or cause serious bodily harm, is caught under the present law by manslaughter. And where my Lord said that Lord Hutton in Powell and English had effectively, by endorsing what was said in Anderson and Morris, got rid of the situation of the possibility of a conviction for manslaughter in such circumstances, is not in fact correct. If we keep that open, if we go perhaps to Powell and English.
While we're doing so, I mean, one may be able to, my statement may have been too broad, one may be able to envisage some particular case where you could get manslaughter, but would it not be right that it has at least substantially squeezed the gap and has led, therefore, to the introduction in many prosecutions of an alternative count of violent assembly, which never used previously to feature in indictments?
No, the principle is very simple. The difference, where manslaughter is problematical in the weapons cases, is where the secondary party does not foresee the use of a weapon. If the secondary party does not foresee the use of the weapon, which is the murder weapon, then under the basic doctrine of parasitic accessory liability, there will be a verdict of not guilty. Because in the words of the Lord Chief Justice in Anderson and Morris, the use of a knife or a gun in those circumstances is an overwhelming supervening event which effectively knocks out and relegates to history all that has gone before. And it was in that context that Lord Hutton in Powell and English said, relying on the dictum in Anderson and Morris, that the Court of Appeal in Powell English was right to rule that a manslaughter verdict on those facts was not available because English did not contemplate or foresee the use of the knife. What he foresaw was something else, and that overwhelming supervening effect, eventually, it's almost as though instead of standing next to his co-confederate, a complete stranger had rushed out of the bushes or a nearby building with a knife and had stabbed the man who was being beaten up to death. It's the same principle. It doesn't matter whether it was a complete stranger rushing out of a building to do that, or whether it was the man that the defendant was with, whom he did not foresee had a knife. As a matter of principle, the effect is the same. And therefore, Reed, in fact, is an example, because in Reed, my lord may remember that the defendant who was appealing was jointly in possession with the other two who were convicted of murder of weapons. And the jury, in fact, perhaps rather fortuitously, acquitted him of murder, and therefore he appealed on the basis that as the jury had acquitted me of murder, and as this was a weapons case, there was no proper basis upon which the jury could then have returned a verdict of guilty of manslaughter.
That's right. And that's why he relied on Anderson and Morris, in which Mr. Lane had been counsel, and that led them to analysing what Anderson and Morris really decided.
Yes, but he relied on Anderson and Morris with this difference. In Anderson and Morris, the production of the weapon was the overwhelming supervening event. It wasn't in Reed, because they all three of them went out armed with weapons. And the Court of Appeal in Reed said there was a logical justification for the jury's verdict, which was although Reed was armed with and knew that the others were armed with weapons, including the weapon that caused the fatality, the jury was entitled to infer that he must have contemplated that some harm would be caused by those people. In other words, that there would be the risk that the weapons would be discharged, or a weapon would be discharged, and it would cause some harm. And of course, if he contemplated that, then if it was an unforeseen consequence that the person at the other end of the gun died, that wouldn't matter, which is what Lord Lane had said and the Court of Appeal had accepted in Anderson and Morris. So there is still a place for manslaughter, and on this particular discrete issue, that's now clear because Mendes and Thompson was considered in terms in the case of Carpenter. My lords, Carpenter is at Authorities Bundle number 2, tab 17, electronic page B594.
594. Yep.
This was a case where the appellant was the mother of the principal who was convicted of murder. There was a prearranged family fight between the principal and a young man from the other family, and the mother assisted by preventing, once the son produced a knife, by preventing any members of the victim's family going to the assistance of the victim. She was charged with murder, but was in fact acquitted of murder, but was found guilty by a majority of manslaughter. And at paragraph 8 of the judgment of Lord Justice Richards, he there sets out the route to verdict that the trial judge gave the jury, and the relevant direction is number 5 at the bottom of the page. The first direction dealt with murder. If no to 3, go on to answer this question. Is it proved that it says he because a similar direction was given in respect of the father? And if you just turn over the page to the top of 597, the judge said you should read these directions by substituting the name of the appellant, Tracy Carpenter, for the name of Paul Carpenter, who was her husband, who was also convicted of manslaughter. Is it proved that he knew that Joe Carpenter had a knife and intended to use it to cause some injury or harm, but falling short of killing or causing really serious injury? or he realised that Joe Carpenter might use the knife to cause some injury falling short of really serious injury, and nevertheless took part by restraining Frederick Price, Sr., to prevent him from intervening in order to protect Shane Price. If yes to 5, your verdict will be guilty.
Yes, I follow your point.
And you can see, my lords, that the appeal was predicated on the basis it had to be murder or nothing. And indeed, it appears from what was said in the judgment that the reason leave was given was that leave was given because it was thought that Mendes and Thompson was inconsistent with another line of authority.
Yeah.
And without going into detail, my lords can see at paragraph 16, the court referred to the case of Roberts and others, quoting from the judgment of Mr. Justice Laws. At paragraph 17, they quoted from the judgment of my Lord Justice Hughes then in A and others.
Yes.
And then at 18, they cited from the judgment of the Court of Appeal in Yemo and others, and said at 21, all this is fundamentally at odds with the case advanced by Mr. Ted on the present appeal. Mr. Ted submitted, however, that it cannot stand with Mendes and Thompson, which doesn't appear to have been cited. And then, as my Lord sees, that the passages or the paragraphs in Mendes and Thompson are cited, 21, 22, paragraph 31 from Mendes and Thompson was cited, and then top of page B603 on reference to Reed, and then at paragraph 28 we are satisfied, because of course Mendes and Thompson was a case in which the appeal was allowed because the judge's directions didn't make it sufficiently clear to the jury that in order to convict the secondary party there, it being a knife killing, the secondary party had to have foreseen the use of the knife.
Yes, I follow your essential points that A, this was a different type of case from Mendes, and B, that there can be some circumstances in which manslaughter can still arise.
Yes, the key is in whether it's murder or whether it's manslaughter, and whatever the intent, the key is, was the act that caused death, rather obviously than the intent to kill or inflict grievous bodily harm, but was the act that caused death one that the secondary party did not foresee or contemplate? If the answer to that critical question is no, then the secondary party cannot be, and rightly cannot be, convicted of either murder or manslaughter.
Well, I just wonder.
Yeah.
At least if it comes, if by did not foresee or contemplate, you are sufficiently particular to insist on foresight or contemplation of the particular weapon which was used. Can we go back to? Sorry, can we start one stage back? Unlawful act manslaughter. Is that an unlawful act which carries the objective risk of some harm and results in death?
There's a distinction, my lord, isn't there, between the unlawful and dangerous act manslaughter and the assault type manslaughter. If I punch Mr. Stevens,
Yes.
and he falls and he cracks his head on the ground and he dies,
Yeah.
I am guilty of manslaughter on the basis that I have assaulted him and caused his death, and my intent was to do some harm to him.
It doesn't matter whether your intent was to. You had, in fact, in that instance, the intent to do some harm, but you don't need that, do you? An unlawful act manslaughter is committed, as I understand it, whenever one does an unlawful act which objectively carries the risk of some harm. Newbury.
Yes.
Now, of course, in the case of an assault, since an assault has to be effectively has to be deliberate, it will also be a case that it is subjectively likely to cause some harm. But that's not essential, is it?
No, it's not in an unlawful and dangerous act type of matter, because they will tell
and dangerous only means, as I've always understood the law, but correct me if I'm wrong, and dangerous only means objectively liable to cause harm.
Yes, in the mind of a sober and reasonable person.
Exactly.
My lord's quite right.
Right.
The
Well,
reality
if that's right,
Yes.
if the mob circles the unfortunate victim or victims in the park or wherever, threatening and assaulting and intimidating, that's an unlawful act, isn't it?
Yes.
And if one of them produces a knife and stabs him, then subject only to the overwhelming supervening deus ex machina,
Yes.
why isn't it manslaughter?
Well, in that instance, my lord, that is manslaughter. I was concentrating in the context of my interchange with Lord Toulson on what is often left to the juries in these spontaneous violence cases, and what is left to the juries, and is left to the juries where the evidence justifies leaving it to the juries, is the simpler manslaughter alternative, which, based, of course, upon secondary liability as opposed to principal liability. And most judges tend to find, particularly, the reason it's dealt with in this way is because the evidential basis for the direction is that the defendant realises or foresees the use of a weapon. Now, where you foresee the use of a weapon, a direction to the jury of an assault-type manslaughter is simpler than perhaps the unlawful and dangerous act-type manslaughter, because most people would contemplate, would they not, that at least some harm is going to be caused if somebody assaults somebody else with something such as a knife. And therefore, in those types of cases, bearing in mind that one of the objectives is to keep it as simple as possible for the jury, I would expect, although my lord is quite right in what he says, I would expect in that type of case the jury to be directed on the simple unlawful assault type manslaughter.
That may well be. But now let's think about the proposition that the production of a weapon is necessarily an overwhelming supervening event of the kind described by Lord Parker in Anderson and Morris. Is it?
No. It can be, but it need not necessarily be.
Absolutely not, one would have thought. Precisely in the kind of case where you've got a mob of people who are bent on intimidating or threatening or doing damage to one or more opposition. It isn't necessarily always one. It's sometimes equal numbers on the other side. But why does everybody seem to accept that the production of a weapon necessarily is such an overwhelmingly supervening event of a kind that nobody, miles outside what anybody ever, whatever purpose there was? Whether it was right in Anderson and Morris that the production of the weapon had that effect, I have absolutely no idea. But I'm very worried about the proposition, which seems to have been spawned by Anderson and Morris, that the production of a weapon always is.
In fairness to Anderson and Morris, if one reads the judgment of Lord Hutton in Powell and English, one would also get the impression that the production of a knife in what is otherwise contemplated to be an assault involving fists and feet is also regarded as
Yes, it is.
As a fundamental departure. That's
Absolutely,
really
hence
how you
English.
read.
Hence the decision in English.
Yes.
But is it right?
Well, perhaps a rather more sophisticated test was in fact suggested by my Lord Toulson in Mendez and Thompson.
So we come full circle. Yes. Well, then where's Mendez?
It's tab 135. I won't give the electronic page number as it's meaningless. It's internal page 889 of the report.
Yeah.
I think the paragraph number is usually the most helpful.
Paragraph 45, my lady, of the judgment.
Altogether more life-threatening, yes.
Yes, at paragraph 40.
Well, the background to this, of course, was that Rahman had sparked a line of appeals where people have been saying, is a knife more dangerous than a block of wood, and
Yes.
it's more dangerous than that.
Yes.
And I was trying to look at what was really underlying the approach. in Rahman and look at the sort of level of danger rather than necessarily injury, because we know that a shoe can do just as much damage as something else. The Law Commission had looked at this fundamentally different question, and had expressed some views which I borrowed at paragraph 43.
Yes.
I mean, it's obvious, isn't it? Again, it's that you can have the Deus Ex Machina, the off-the-wall event.
Yes.
The kneecapping case is a good example of it.
Which was the passage you wanted to go to?
But
sorry, my lord.
I'm just trying to run down the proposition that the use of the production of either a weapon or a different weapon will always, or even normally,
it's not,
take the case out of the ordinary rule of manslaughter.
at the risk of mixing my metaphors, the test is not as blunt as that. It is a rather more refined test. You cannot, my lord, I agree, you cannot simply say, as is black and white, that the production of a knife in a case where a knife is produced is by definition a fundamental departure. You can't, because it is a more, these things are all fact specific. And that is why the judge's directions to the jury in cases will often be substantially different from one case or another. The principle may be the same, but this is exactly what the judge will have to grasp with. And in these types of cases, inevitably, I know from my own experience, that the judge will hear submissions at the end of the prosecution case, indeed at the end of the defence case, as to how he's going to direct this particular jury on these particular facts, on what I call the fundamental departure rule. Is he going to tell them? Is he going to direct them as a matter of law that if a particular defendant, a secondary party whose case they are considering, did not foresee or contemplate the use of a knife, then their verdict must be a verdict of not guilty? Or is it going to be somewhat different? There is no golden rule, despite what was said by Lord Hutton in Powell and English. The respondent would certainly ally itself with the type of language that was suggested by my Lord Tilson in Mendes and Thompson, because it is more discreet to the issues in a particular case. And also it gets across the point. Fundamental difference or fundamental departure is perhaps an unhappy turn of phrase. It was one that was, in fact, I think, used by counsel in Powell and English. Lord Hutton recited counsel's submission, and then Lord Hutton said, essentially, I agree with that submission, and that's how fundamental departure appears to have metamorphosed from a submission of counsel into the sort of rule that judges now give juries during the course of their directions.
He was talking about murder, of course.
Yes, he was.
Which is the paragraph in Mendes that you say is more or less right?
It's paragraph 45, where my lord sets out the essence of counsel's argument in that case.
With a bit of help, I think. Is paragraph 44 right, that what you've got to concentrate on is really the nature of the conduct and likely harm as intended and as in fact inflicted, that if there's a common purpose is to kill, then it really shouldn't alter D's liability for murder, which way it's done.
Correct.
The potential problem arises in GBH cases because there's such a wide spectrum between what can be different forms of GBH.
My lord, and Powell in English was a paradigm example. Mr. Powell was guilty of assaulting the victim, intending to inflict grievous bodily harm on him because he assaulted him with his confederate with wooden posts. The difficulty in Powell, as my lords heard yesterday from Mr. Knowles, is that after he'd run off, his confederate continued the assault and then produced the knife. Now, although Powell is put as an example of a fundamental departure case, because it's a knife as opposed to a post, you really have to look at Powell in all of the circumstances in Powell. You can't really ignore the fact that on one view, no doubt defence counsel speaks to the jury would have been along these lines, that Mr. Powell is apparently to be found liable for murder when the act of murder is committed and he's got a policeman's hand on his shoulder. You can see that that's why you have to look in these sorts of cases at all of the circumstances, and judicial directions to a jury have to be that fact specific. But it does have the benefit of this area around what is foreseeable, which is not simply a simple question, did you foresee that there would be a knife? Did you foresee this? Did you foresee that? The jury ought to be told to look very carefully at all of the evidence, and perhaps the right way of putting it is to use the sort of phrase. In Rahman, for example, the House of Lords clearly approved of what I think they call the homely phrase of the trial judge in that case, when he directed the jury on the fundamental departure point by saying they're not guilty if what you thought was happened was in a different league. That sort of language. And judges are always being encouraged to direct juries in a language that they understand. Obviously, in a different league would include the type of case of somebody emerging out of the shadows and doing it. But provided the jury are told in their directions what is the correct approach by reference to the evidence in the case, then the respondent submits that this test is a good one.
In the English type situation where one of the assailants has been removed or has removed himself, doesn't matter which, might it be sensible to say to juries, well, the question for you members of the jury is whether his assistance and encouragement was still operating on the
Yes.
principle when he did what he did?
Yes.
Well, that's one of the questions that's been occurring to me in the course of this. Now, you say a deliberate choice is made to continue
Yes.
to lend aid. In that sort of situation, of course, the opposite deliberate choice has been made. The person's peeled off,
Yes.
left the crowd
But
surrounding.
there is now no longer a connection. Whether one refers to it as a causal connection or not, it's quite clear on the authorities. Working backwards, as you always have to do, from the act of murder itself, was that act linked, connected to the crime that the secondary party has gone along with? And in the question of Powell and English, even if you didn't say that Powell ought to be acquitted because this was not a fundamental departure case, you could also say that by the time the fatal act was committed, there was in fact no longer a link between what it was that English had lent himself to and what it was that the principal had done.
We had that in Stringer, because that was a case where some of the people peeled off long before the chase reached a dangerous stage. Others stayed and were there more or less in on the kill.
Yes. And of course, it was in the two authorities of Mendes and then Stringer that my lord in his judgments discussed to what extent the principles of causation were relevant here. And you did comment in the second of those cases, Stringer, that there had been some academic criticism of your comments, but you justified them by saying that you were in fact doing no more than following, I think, what the Law Commission had set out in one of its papers. And you were not saying it was...
quite a good precedent for it. I mean, one
Yes.
had some of Foster on one side, one had Lord Parker and Anderson and Morris, and but it became, I think, a rather unhelpful academic debate, because it really turned around what do you mean by principles of causation. There are other forms of causation than the but-for test. And it seemed to me that in cases like Abel, you can see that underlying the moral justification for finding somebody guilty of murder is that they, by their assistance and encouragement, have made some contribution
Yes.
to the event. Whether or not it would have happened in any event is neither here nor there.
Yes. Often expressed by saying that there is only liability for the secondary party if at the time the principal commits the murder, he's still doing that in the course or furtherance of the crime A that the secondary party was a party to.
Would you agree that there is some merit, if one possibly can, of getting back to the original words and asking oneself whether P's act was done with the assistance or encouragement of D?
Well, that in effect is a legal prerequisite, isn't it? Because that's what makes. My lord's quite right. That's what makes D liable.
You say that's one of the two main ingredients, and the other is intention.
Yes.
Yeah.
Unless it can be said, because there must be an actus reus by D that makes him liable for the second offence.
Of course.
And it's usually either participating physically or it's some form of encouragement. But my lord is quite right. The jury, in order to convict the secondary party, has to be sure that at the time that the principal kills, the principal is at that time has the encouragement or assistance of the secondary party. Otherwise, there's no actus reus for the secondary party to make him criminally liable.
That's quite difficult, isn't it? If you're thinking of the mob chase, I'm thinking of those terrible events in Victoria Station.
Yes.
And you have a whole group of lads who are pursuing another one, but say there isn't a common purpose to kill, or even necessarily GBH at the time, but it's foreseeable that something terrible will happen. And there are less willing participants who peel off from the mob, probably before the victim is caught. Now, applying the test that you have just suggested is very difficult in those circumstances, isn't it? One wants to encourage them to peel off. I mean, one wants them actually to be encouraged to think better of it at the earliest possible stage, rather than to carry on the basis, well, in for a penny, in for a pound.
Yes. Well, in those cases, those that peel off, as it were, before a jury are going to have a far better prospect of an acquittal than those who, in the vernacular, are in at the kill.
Well, yes, but should they? I mean, what I'm getting at is what's the principle?
Well, the principle is that unless at the time that the second offence, which is the murder, is committed, it is being committed, one, with the secondary party having an actus reus, that is, by participation or by encouragement, being liable as a secondary party, and B, that the commission of the second offence is committed in the course of or the furtherance of the first offence, then the secondary party will, on the present state of the law, be acquitted and will have a defence. And the principle is sufficiently flexible because, as I've indicated, it's not just a question of foresight, it's an oversimplification. There are so many other elements to what is being called principal accessory liability than that.
Well, that's what we're trying to... Yes. I'm trying to explore. How far does that go?
Stringer did actually raise precisely those questions.
It did.
It was fascinating to see that it was where we reached in principle was pretty much where Hale was and where Foster were, because the problem itself doesn't change.
No. But the problem doesn't change, but the present answer is no more unjust. The present test is no more unjust. It still caters because of all of the various elements to it and all the various matters that the jury must be directed to take on board. It does still cater for the acquittals of those who were there at the outset, assisted at the outset, but have in fact, for whatever reason, whether they thought better of it or whether they simply got fed up with it, have simply not been present at the time that the fatal act is committed. And Stringer is a good example of that.
But this aspect, important as it is, namely what is the actus reus and what acts will constitute, may properly be regarded as assisting and encouraging, is in a sense a constant, whether you are using for the mens rea element foresight or purpose.
Yes, that is quite correct.
So in a sense, it's tangential to your argument, isn't it?
It is, but the foresight test works very well with it,
Well,
as you would expect.
But it's also a bit helpful for people like me who are coming to this comparatively fresh to look at the totality of
Yes.
what's involved and ask oneself, well, where is moral responsibility here?
Yes.
Does intentional foresight fit better with the acts for which one may be responsible? That's why I'm...
am I right in thinking that no academic and no court has actually attempted to define what degree of assistance will be needed in order for a jury to conclude that it was done with the person's assistance or encouragement? There isn't anywhere, I think, a formula put forward as, so to speak, a slide rule by which that judgment can be made.
Not a formula, but obviously one of the matters that often has to be dealt with by way of direction is the significance or the relevance of presence.
Sure.
But my Lord's quite right. There is no definition of what is meant by assisting or by encouraging. One can put those verbs
Yeah.
in different ways, but there is
Find
no...
lots of examples.
Yes.
But for perfectly understandable reasons, no attempt
No.
made to put forward a formula.
No, because they're ordinary English words, and juries are trusted to understand ordinary English words they can understand.
We're very keen on leaving English words that are simple to the jury,
Yes.
rather than an elaborate academic definition would actually make the task of a jury even more difficult than it might be.
Yes.
And the jury will very often have to take a common sense judgment on the degree of connection.
Indeed.
I encourage somebody to go and pinch a bicycle. He does it 6 years later. Well, is the degree of connection such that you can really say 6 years on he was acting under the influence of the encouragement? You can multiply examples.
You can. And that's why juries are always... One constant in any summing up that I've ever sat through is the jury are always told to use their common sense. It is now.
Oh, dear. One person's common sense can be another person's hopeless idiocy.
But my Lord's point is a fair one. The juries are trusted to apply their common sense to the directions of law that they give and to apply the directions to the facts that they find proved. It happens all the time. And there seems to be satisfaction with the way that it currently works. That's obviously another question. My Lord, I've been diverted and I've dealt with the manslaughter submission that I was going to make. Going back to where I was, and the basis and justification for the foresight test. Well, my lords and my ladies have already been taken through the authority. You've already been taken to Wesley Smith by my learned friend, Mr. Knowles, and I don't propose to do that again because he did refer you to the relevant passages. It's just interesting that in Wesley Smith was later regarded, certainly by some of the judges in the Australian case of Johns, as authority for the foresight contemplation test, albeit that as expressed in Wesley, that it was allied to it. Effectively, in Wesley, it was said, he, the appellant, must have contemplated the use of the knife, and because he contemplated the use of the knife, that fell within the common purpose. So the language in Wesley uses both types, uses both the modern way and the older way. It's interesting in Wesley that the judge didn't direct the jury, it would appear, along the lines of common design or common purpose. Anderson Morris, however, which is the next chronologically, is different in that you won't find reference in Anderson and Morris to foresight. It appears that Anderson and Morris was dealt with on the basis of what actually happened being outside the common purpose. One interesting aspect, one interesting piece of language that was used in Anderson and Morris, which we will find in Authorities Bundle 2, Tab 15, Electronic Bundle B587. It actually starts at 576 because it's the one that's copied backwards.
Yes. Just to keep us on our toes.
And my lords and my lady have been referred to this passage already. It's at page B584 towards the bottom of the page. And of course, the submission that Mr. Lane made was against the background that his client had been convicted of manslaughter, and he'd been convicted of manslaughter on the basis of the misdirection of law, which appears at the top of the page. The misdirection being that if the jury thought there was a common design between the two defendants to attack the victim, but that was not proved in the case of Morris, then because Anderson produced without Morris's knowledge the knife and used it to kill Mr. Welch, an act, according to the judge, outside the common design to which Mr. Morris is proved to have been a party, then you would or could, on the evidence, find it proved that Anderson committed murder and Morris would be liable to be convicted of manslaughter. So the judge was telling the jury, directing the jury, effectively, if Morris isn't part of the common design because he hasn't anticipated or contemplated the use of the knife, you'll still convict him of manslaughter. And it was against that background, the respondent submits, that the submission was made by Mr. Lane before the Court of Appeal that where two persons embark on a joint enterprise, each is liable for the acts done in pursuance of that joint enterprise, but that includes liability for unusual consequences, i.e., if the man that you punched died, that's your tough luck. If they arise from the execution of the agreed joint enterprise, but, and this is the crux of the matter, if one of the adventurers goes beyond what has been tacitly agreed as part of the common enterprise, his co-adventurer is not liable for the consequences of that unauthorised act. And there you see the use of the verb unauthorised. And I'll always remember from the exchange with Mr. Knowles yesterday that when Chan Wing Soo was decided, Sir Robin Cook used the verb authorised to effectively equate it with contemplation. And insofar as one can work out why that might have been, because of course, as my lords and my lady know, the court in Chan Wing Soo did refer to Anderson and Morris. In fact, I think it referred to Anderson and Morris very shortly after Sir Robin Cook set out the test. I know we've been there before, but Chan Wing Soo is in volume 1 of the Authorities Bundle at tab 2, electronic page B11. And
Yep.
it's clear from the facts of Anderson and Morris that, as my Lord Hughes pointed out, if one looks at B18, page 175 of the report,
Yep.
the judge's direction to the jury is notable for two things. Firstly, the judge, it would appear, didn't give the basic accessory liability direction. He gave what's called the parasitic accessory liability direction, and he didn't give a common purpose direction in that passage. And it was because he hadn't given the basic accessory liability direction that the court, Sir Robin Cook said this further down the page just above F. He starts at F. It should first be recalled that a person acting in concert with the primary offender may become a party to the crime, whether or not present at the time of its commission, by activities variously described as aiding, abetting, counselling, inciting, or procuring it. In the typical case in that class, the same or the same type of offence is actually intended by all the parties acting in concert. In view of the terms of the directions to the jury here, the Crown does not seek to support the present convictions on that ground, so it couldn't be supported on the basis of basic accessory liability. The case must depend rather on the wider principle whereby a secondary party is criminally liable for acts by the primary offender of a type which the former foresees but does not necessarily intend. That there is such a principle is not in doubt. It turns on contemplation, or putting the same idea in other words, authorisation, which may be expressed but is more usually implied. It meets the case of a crime foreseen as a possible incident of a common unlawful enterprise. The criminal culpability lies in participating in the venture with that foresight. And it's at that point that Sir Robin then cites from Anderson and Morris the passage that I've just cited to my lords at page 11819.
Yep.
And so it's apparent there, isn't it, that it's another way of putting the common purpose test. Sir Robin comments, having quoted from Anderson and Morris at page B19 underneath the citation, in England it appears not to have been found necessary hitherto to analyse more elaborately the test which the jury have to apply. In other words, the test is certainly set out in Anderson and Morris there. Didn't talk about contemplation or foresight. And that is why Sir Robin Cook then went on to deal with Johns. I pause. I think my Lord Toulson has asked at least twice when counsel has been on the feet, is anybody going to take us to the case of Johns? And as neither of my learned friends before me did it, it looks as if it's fallen to me.
Well, quite a lot of reliance was placed on it.
Indeed, and in the same way that my learned friend Miss Gerry can't really do this appeal by not taking the court to Powell and English, we can't really do this without taking the court to Johns, which was relied upon by Sir Robin Cook. As I say, it's bundle A1 tab 7, which is electronic page 142. I think the first paragraph of the judgment of Chief Justice Barwick is rather garbled. The applicant for special leave to appeal was convicted by the rob and wounding at the time of the assault. This was, in fact, a case where there was a conviction for murder, and this was a case where there was a principal, where there was a secondary party who was also present at the scene, and where also there was an accessory before the fact. So you had all three. You had the principal, the accessory who was present, and the accessory before the fact who wasn't.
The facts are most simply summarised at B150 in the judgment of the majority. Well, they all agreed, but the three-judge judgment of Mr. Justice Mason, Mr. Justice Murphy, and Mr. Justice Wilson begins with a summary of the facts, paragraphs 4 and 5.
Yes, my lords can see that if one, because it's set out very neatly in a single paragraph, if one looks at page B143, paragraph number 7, one can see quoted in the judgment of Chief Justice Barwick the direction that the judge gave to the jury. And the judge gave the jury the same direction in respect of Watson and Dodge. If the parties, that is the applicant, Watson and Dodge, must have had in mind the contingency that for the purpose of carrying out their joint enterprise out or attempting to carry it out, the firearm, i.e. that carried by Watson, might be discharged and kill somebody. He told them if the party of the enterprise must have been aware of such a possibility or contingency, then he is responsible for the death, whether or not he was present at the time of the killing. His Honour also said the use of the pistol must of necessity be by the party carrying it, and a jury would be entitled to hold that all must be taken to have had in mind such a possibility, i.e. of its lethal use, when they assented to and encouraged this joint enterprise of robbery with arms. And at paragraph 10, having cited the submissions at paragraph 8 of counsel for the applicant, the Chief Justice said that the submissions were clearly unacceptable. He then dealt with no reason why the participant in the common design or enterprise, joint enterprise, cannot be held as responsible as other participants, simply because he remains an accessory before the fact. He then, having dealt with that, says, in my opinion, the participant in a joint enterprise or common design is liable for all that occurs in the course of its execution, which is of a kind which fairly falls within the ambit of the enterprise or design, though he's not present at its execution, and is only sought to be made liable as an accessory before the fact. The responsibility for acts done within the ambit of the enterprise or design cannot be confined to those who actively participate in or are present at the performance of the acts. He then made the important comment at paragraph 11 that the court there was concerned with criminal responsibility under the common law, something that he repeated at paragraph 14. The learned trial judge's summing up, of which I've quoted the relevant parts, did correctly express the common law. The participants in a common design are liable for all acts done by any of them in the execution of the design, which can be held fairly to fall within the ambit of the common design. In deciding upon the extent of that ambit, all those contingencies which can be held to have been in the contemplation of the participants, or which in the circumstances ought necessarily to have been in such contemplation, will fall within the scope of the common design. And then if one moves to the judgment of Mr. Justice Stephen was quoted in Chan Wing Soo. I think what was quoted in Chan Wing Soo was paragraph 21 of the judgment of Mr. Justice Stephen at B149, where he expressed approval with the joint judgment, which we can see starting at under paragraph 22, was given by Mr. Justices Mason, Murphy, and Wilson.
Yes.
Just going back at paragraphs 11 and 12, I simply invite my lords to read it, because there Mr. Justice Stephen gives I suppose one might call it a policy justification for why it is that secondary parties are liable for contemplation of possibilities rather than contemplations of probabilities.
Thank you.
And then we move to the judgment of the three judges, and they start at paragraph 8 on page B150 with setting out the Crown's reliance upon the doctrine of common purpose or common design in order to involve Dodge with complicity as a principal in the second degree and the applicant as an accessory before the fact, and in essence say that the judge was right to direct the jury as he did. And then at paragraph 9...
Well, just before you do that, they summarise the judge's direction to the jury, line 4, that the principal in the second degree may be held liable pursuant to the doctrine of common purpose if the act constituting the offence was one which the jury might regard as being within the contemplation of the parties, yes, as an act done in the course of carrying out the particular venture upon which they had embarked.
Yes.
So it's looking at what is the venture on which they've embarked, and if they find that it was within the joint contemplation of the parties, they may find that it was part of the joint venture.
Yes, it's linking crime B, the murder, with crime A, the robbery.
Yeah. Yes.
And then at paragraph 9, the judges set out the objection that was taken on behalf of the applicant.
But now this is, I think, quite important, because if one's looking to see was the High Court conceiving that it was changing the law, it's relevant to look at what was the issue, and we can see that the appellant was saying that there was no objection to the way in which the summing up had been put had it been applied to a principle in the second degree,
Yes.
but that a different test applied
Yes.
in relation to an accessory before the fact, and that's the argument which is being addressed.
It is at paragraph number 9. And at paragraph number 11, the three judges deal with the problem here is one of expressing the degree of connection. Of course, very relevant where this applicant was an accessory before the fact. The problem here is one of expressing the degree of connection between the common purpose and the act constituting the offence charged, which is required to involve the accessory and the principal in the second degree in complicity. The applicant referred to some cases in which reference has been made to the offence charged as a probable consequence of the common purpose and sought to gain support from them. Two comments should be made about these cases. One is that none of them lends any countenance to the notion that the doctrine differs in its application to an accessory before the fact as compared with the principal in the second degree. The second comment is that the observations in the two cases which the applicant principally relies relate not to the common law, but to the interpretation of one only of two relevant provisions in statutory criminal codes. It should be noted, as we'll mention later, that there is support for the view that the relevant code provisions reflect the common law. And then the judges then do refer to the cases that the applicant relied upon. And interestingly, over the page at B153, as part of the review by those three judges of earlier authority, they cite Wesley Smith and cite it for support of the contemplation that the knife might be used approach. And then at paragraph 24, and this was, I think, the paragraph with which Mr. Justice Stephen expressed agreement, in our opinion, these decisions support the conclusion reached by Chief Justice Street, named as an accessory before the fact bears, as does a principal in the second degree, a criminal liability for an act which was done within the contemplation of both himself and the principal in the first degree, as an act which might be done in the course of carrying out the primary criminal intention, an act contemplated as a possible incident of the originally planned particular venture. Such an act is one which falls within the party's own purpose and design, precisely because it is within their contemplation and is foreseen as a possible incident of the execution of their planned criminal enterprise.
In other words, in the language we've been using, it's a conditional intention.
Yes, and a conditional intention here on the facts would have been one of some relevance, because this was a pre-planned robbery with quite meticulous detail about one person dropping them off in the car, then turning up in the car after it had happened to take away the swag and conceal it, with one man with a gun going to accost the victim with his other mate by his side. So there was actually quite a scope, one might say there, particularly as it was known that the principal was armed with a weapon and had made some fairly aggressive comments before it all started, which the accessory had overheard. So, yes, my lord, the evidence of the facts in this case, that would be right. And then at paragraphs 26 and 27, the court then, the three judges then deal really with the reasons why it's possibility as opposed to probability.
Well, those two paragraphs really contain the kernel of the ratio, don't they?
Yes.
Yes. And in 26, they reject the argument that had been advanced by the applicant, because they say, suppose a plan made by the principal offender and the accessory to rob premises, it's agreed that A will carry a loaded revolver and use it to overcome resistance. In the unlikely event the premises are attended, it would be make a nonsense to say that he wasn't liable when that conditional intent was carried out, simply because the prospects of needing to do so were low.
Yes.
And that's why they reject that argument. And then say, 27, ample evidence from which jury could infer the applicant gave his assent to a criminal enterprise which involved the use of a loaded gun in the event that Morris resisted or sought some assistance. Jury could therefore conclude that the common purpose involved resorting to violence of this kind should the occasion arise. So it appears, doesn't it, to be well in the classic line of authorities going back to the poacher cases, that if you carry guns intending to use them if necessary, that's a contingent purpose, and when that is executed, everybody who's party to the scheme is liable.
One struck by the use of the word assent.
Yes, it's an illustration that the arrangement in this case would have been a crime whether you applied the foresight test or whether you applied the common purpose test.
Now, given that your acceptance that what has happened in Zhang has really been a significant change in the substantive law, I find it difficult to see that that has a jurisprudential foundation in the ratio of Johns.
What you can argue, of course, the ratio of Johns is confined to whether or not the same legal test applies to an accessory before the fact as applies to a principal in the second degree who's present as an accessory.
You don't have to put it that narrowly, I accept, but if you take paragraph 27 of the judgment, you agree it represents the kernel of it. They treat it as a perfectly straightforward case of people going out with a common intention to use guns should occasion arise.
My lord, yes, but you should not put to one side all that they have said before, which is that their understanding of the common law is that the secondary party is liable if he has foresight, in this case, of the possibility that the gun would be used and would be discharged.
But it's only foresight to establish that you're within the scope of the joint venture.
It's an example where
It's the evidential basis.
It's an example where you say that, yes, provided that foresight is there, then that means it's within the common purpose.
Yeah, because you're saying if you participate, if you go on foreseeing this, you've tacitly assented to participate. And it's foresight being used as evidence.
Yes, but that's why, my lord, I repeat that this case is about directions to a jury.
Well, yes, but I think what's being put to you is that contemplation is a dangerous word. On the facts of this case, contemplation may have been equivalent to intention or participation, but say contemplation with sufficient in every case is a non sequitur.
Well, it is sufficient in every case.
Well, that's the question.
Surely you have to be able to say, to bring it within the classic, unless the law changed dramatically, you surely have to be able to say that contemplating something, you then went on and tacitly assented to the venture.
Yes, because it's not contemplation or foresight looked at in a vacuum. It's the whole thing. It's when one talks, for example, about authorization, which was discussed yesterday. Authorization, I think Mr. Knowles this morning talked about endorsement and approval. You can't look at authorization so narrowly. In this type of case, it is lending yourself. It is going on to participate. It's not authorization. You can't necessarily equate authorization with foresight, because all foresight means is, well, I know that something might happen. That's a long way, it might be thought, from saying I'm authorizing what has happened. What you have is you have foresight, and with that foresight, you then go on to be a party in the crime that is on the indictment. And it's that participation with that knowledge or with that foresight that amounts, insofar as you want to look for another word such as authorization. Not only do I foresee the crime that may be committed, but with that foresight, I'm going to help you, because there has to be an actus reus, I'm going to help you to commit that crime with that foresight. And that can properly, surely be termed, not, again, I suggest you would direct a jury along these lines, but that can properly be regarded as authorisation.
But how do you reconcile the passage you just looked at with paragraph 63 of what Ms. said in Brahman, where you expressly reject the common purpose?
Well, Lord Brown is there talking about directions to a jury. And you don't direct a jury using the phraseology common purpose. That's what Lord Brown is saying. If by directing the jury to use foresight, participation, all the other things that make up this doctrine, in language that the jury understands, that's much better than, you'll only be met, you may well be met with a series of questions from the jury as to, well, what do you mean by tacit agreement? What do you mean by authorisation? Can we have some more help with that? They're not the sorts of words that the jurors, many of the jurors, will necessarily be familiar with in their everyday lives. And that's why the test as formulated, we submit, is a sound one. Well, that was the review of John's that Sir Robin Cook carried out.
Can I cut across your bows for one other reason? I apologise. I'm very conscious of the time, and there's one point which hasn't really been dealt with very much in the argument to date, and I would like your help on, and I think it's only fair to flag it up before the short adjournment. And it's to do with the inchoate offence of intentionally encouraging or assisting an offence, which we've now got in Section 44 of the 2007 Act. Now, that's not in the authorities bundle, and whether I think we have copies somewhere, but the point is this. Parliament there codified law on inchoate offences and plugged the gap which there was in some instances between attempt and incitement, because there wasn't an offence of intentionally encouraging or assisting an offence as distinct from attempting to commit one or inciting one. And it is now a statutory offence for a person to do an act capable of encouraging or assisting the commission of offence if he intends to encourage or assist its commission, and it carries the same penalty as the substantive offence. Subparagraph 2, but he is not to be taken to have intended to encourage or assist the commission of offence merely because such encouragement or assistance was a foreseeable consequence of his act. Section 45 creates an offence where a person does the act capable of encouraging or assisting, not with intent, but believing that it will have that effect. Now, 2 points arise from that. The rather, perhaps less important one, it may be a bit of a forensic point, is that if it's really so difficult for a jury to get their heads around intent and much easier to get their heads around foreseeability, it is interesting that Parliament has set the test of intent and said that foreseeability is not the test. But that's putting that rather forensic point on one side. The question is one which troubles me. If a person does an act capable of assisting the commission of offence, and which he foresees may assist the commission of offence, but doesn't positively intend, then he is not guilty of encouraging or assisting an offence. But, if you're right, and as the law stands, if that which he has foreseen as possible happens, he is now secondarily guilty of the entire offence. And that seems hard at first blush to square with principle or fairness. Why, when Parliament has said that you don't commit the inchoate offence merely because you foresee but you don't intend, when that's all you do, and it so happens that a third party does it, do you switch from being not guilty to guilty not merely of the inchoate, but the full offence?
Yes.
That's the...
Well, my
You-
initial-
if you want to think about that.
Well, yeah, I will think about it. My initial reaction is to make this point, that you're not comparing like with like, because we are here concerned with an individual who has decided and is committing a crime. And the crime that's in issue here is the crime that flows from that. This is a standalone offence. This is a single crime offence. What we're dealing with here is a situation where one crime has led, we know because it's on the indictment, to another. That's my initial reaction at...
It's slightly fast. You've got a half hour plus
I
a
have.
bit more. How are we doing?
I'm going to finish by 2:30, my
Fine.
lord,
Fine. Do you want to?
because I must.
Yes.
So I will.
But well, there's no answer to that. You do have another 3 or 4 minutes if you want. That clock is not.
that
It's
clock
not.
is fast, so-
It is.
That clock is
That
not
clock is
entirely right.
best treated as unreliable.
Well, what I was in fact going, having taken my lords to John's, which was relied upon in Chan Wing Soo, I was going to go back to Chan Wing Soo to see how
Yes.
Sir Robin Cook then dealt with the issue of foresight.
Thank you.
And we're back to Chan Wing Soo, which I think is Authorities Bundle 1, tab number 2,
Yes, indeed.
and my lords, it's page B20.
Thank you.
You can see
Yes.
he dealt on B19 with the Australian case. He dealt with Gush, which is in the bundle.
Yep.
He then dealt with, in the middle of the page, the dichotomy between probability and possibility and rejected probability. He then went on, starting at letter E, to emphasise the subjective nature of the foresight test by citing from the passage in Davis and the DPP to which you've already been taken.
Yes.
And over the page, saying in terms at the bottom of the page, the test of mens rea here is subjective. It is what the individual accused, in fact, contemplated that matters. Then deals with, over the page, onto page 178, the possibility at the top of the page of the jury convicting of either murder or manslaughter. So he clearly thought that manslaughter was still an option in such cases, as indeed the respondent contends that it is. And then finally, towards the bottom of page 178 and over onto 179, he dealt with what he called remoteness,
Yes.
making it plain, however, that rather depended on what issues were raised in the case, and emphasised the point that there was no set formula for judges to use when directing the jury, that they should use the language that they felt was most appropriate, a point that the respondent has gone on about.
Is that a convenient moment?
It is, my lord, yes.
Thank you very much. We'll resume again at 2 o'clock. Court's now adjourned.